Good evening, everyone, and welcome once again to another yet interesting episode of Beyond the Courts with us at NM Law Chambers. I am Malak Bhatt, founding partner of NM Law Chambers, and today we'll be discussing a very interesting judgment that has arisen under the NDPS Act, something which we practice a lot on the trial court side regarding compliance and issues surrounding disposal and seizure of drugs at the spot when a raid under the NDPS Act is carried out. Recently, the Supreme Court, in the case of Yusuf versus State, has held that in case where the drugs are seized by the concerned police officers under the NDPS Act at a spot, if there is non-compliance of Section 52A of the Act, then it is a case where the seizure and the subsequent recording of the seizure is not in compliance of Section 52A, would automatically render the entire procedure conducted under the NDPS Act as being vitiated, the recovery being termed as doubtful, and would ultimately lead to acquittal of the accused. Before we get into the semantics on the issues that the judgment discusses, let's take a step back and see what the provisions regarding Section 52A are. See, typically under the NDPS Act, Section 52 and 52A deal with the procedure and the power of the officers at the time when they conduct a raid. As we've seen mostly in NDPS cases, these are spot informations which are received by the police impromptu by secret informers, where they apprehend the concerned person at a particular spot on the basis of which the secret information divulges. And once the person is apprehended with the concerned contraband substances, narcotic substances or drugs, the material is taken from him, the required seizure takes place, and the seizure is thereafter recorded by the police officer in what is called a seizure memo. Section 52A typically deals with disposal of these drugs. That's the nomenclature of what the statute talks about. However, it has two separate bifurcations under it. 52A1 talks about the procedure on where the central government has to notify rules or orders through which the disposal would ultimately take place. However, 52A2 categorically provides for a procedure which is to take place before a magistrate. Now, the reason for this is that once the drugs or the contraband substances are seized and taken into the custody, to lend authenticity to the drug or the procedure which has followed of the seizure, the entire material is required to be recorded, sampled, weighed, and a particular procedure as has been set out by the law has to be conducted before a concerned magistrate, so that the drugs are sealed, are authenticated before the magistrate, and then it is that procedure which lends credence to the procedure of raid and seizure which is carried out by the police officers. So 52A2 effectively is where the magistrate is empowered to audiograph, videograph, photograph, and record in so many specific terms as to the amount of drug which is seized, of the manner in which the drug was seized. An effective sampling is conducted before him, and only thereafter the material is sealed and sent to the CFSL. Only once this procedure is followed, 52A4 says that this material now becomes primary evidence for the purpose of conducting this further as a material which is then taken as evidence for proving the guilt of the accused. Now, the Supreme Court in Yusuf has actually said that if this part of the procedure is not followed before the magistrate, then the entire recovery procedure stands vitiated and will accrue to the benefit of the accused, leading to his acquittal. However, there is some discrepancy, there is some confusion as to what is the procedure which is to be followed. Because typically, we have seen practically cases where the police officer, once they conduct the search and seizure, they are doing the sampling procedure at the spot itself. They're filling up the CFSL form, they're weighing the goods, they're sampling, conducting the samples on the field testing kit at the very spot itself, and thereafter they are sealing the material and taking it to the magistrate. In some cases, this is not done at all. Once the contraband is seized, the entire material is wrapped up, it is sealed, the officer concerned puts his seal on the seized goods and is directly taken before the magistrate. This conundrum was actually caused because there is discrepancy on what is really to be followed. And the reason is this. Before 2021, there were two standing orders which were promulgated under 52A1, Standing Order 1 of 88 and Standing Order 1 of 89, which provide the manner in which the sampling is to be done at the spot. Now, this sampling is a sampling which is to take place at the very place where the contraband is seized. And there is a manner and mechanism provided that every material will have to be tested and will have to be weighed at the very premises by the investigating officer. And once he is conducting that, the various material will have to be either will have to be seized in separate packets if they are found in separate packets, or will have to be numbered and weighed and sampled separately. Typically, when these standing orders were not followed by the police officers, many cases have arisen where either bails or acquittals have been granted for non-following these sampling procedures. However, in 2016, the Honorable Supreme Court in the case of Union of India versus Mohanlal, well, it was actually dealing with manners and mechanisms to see whether sampling or disposal of drugs is happening or not, categorically held that if there's a statute in place and there's a mechanism provided within 52A2, which is the entire procedures to take place before the magistrate, then it is that which will actually override and supersede any standing orders or norms or regulations which are in place, which is in the form of standing orders 1 of 88 and 1 of 89. Effectively leading to a situation where there was complete confusion on whether the police officer is actually to do the sampling at the place itself, or is he required to simply seize the material, wrap it up and take it before the magistrate. This ultimately was laid to rest in 2022 when the rules were framed, and under the NDPS rules, it categorically provides that while you are at the spot, you are not required to conduct any procedure of sampling. You're not supposed to weigh the goods. You are not supposed to create any samples for the purpose of CFSL. You are simply required to segregate the goods the way they are. You are supposed to serial number them, and you are supposed to wrap them up and put your seals at the spot of recovery. However, the entire procedure of sampling is to take place only before the magistrate. The reason being, this has been a consistent practice of the police before the 2022 rules came in, that they used to mix all the material which was found at the spot and ultimately take a common weight of these samples. They used to number them as a singular sample and take it before the magistrate. However, this would therefore destroy the very purpose of which the seizure has taken place, because in many cases, when there is more than one sample which is found or more than one contraband which is seized, if the material is not taken as is before the magistrate, it is not permissible or possible for the magistrate then to bifurcate this or to actually take authentic data of the material which is seized properly. So we have seen that in cases where the material is not taken before the magistrate directly and the material is bifurcated or is sampled at the spot, the very authenticity of the material was getting lost. This ultimately the Supreme Court has clarified in Yusuf versus State in 2023, where the Supreme Court has finally once and for all said that all that the officer is required to do is seal the material at the spot, put his seal of authority saying this is exactly the material which is seized by me and is not tampered, take it before the magistrate and conduct the entire exercise of sampling, weighing and putting a certificate for the material to ultimately go before the CFSL. It is this procedure which, once followed, lends credence to the exercise conducted by the NDPS officer, and only after this can the material be used as primary evidence for the purpose of an NDPS Act. This is an important development because till this is not done, or if this is not done, then it is a complete death knell to the case of the NDPS officers. The entire proceeding, the entire recovery stands vitiated, and we've seen that wherever 52A has not been complied with, it has led to complete acquittal of the accused, because this is termed as a doubtful recovery. Yet to see is how, now that the standing orders stand repealed, in cases prior to 2022, when before the rules came in and before the standing rules were in place, a Supreme Court's authoritative pronouncement is yet to come as to how these standing orders are to be read in light of 52A. For example, what if a case where the sampling has not taken place at the site, but the officer has at least weighed the material and taken before the magistrate? In cases like this, will the requirement of complying with both the standing orders as well as 52A, will it still be required, or will it suffice if 52A is directly complied before the magistrate, keeping the material just simply intact without really even assessing whether the drug at hand is a contraband substance or not? We are yet to see if this Supreme Court really pronounces on that, but stay tuned in more to see if this really issue gets covered by the Supreme Court or not. For now, this is it from us at NM Law Chambers. Do stay tuned in more for more updates on this issue. Thank you.